Evening and welcome back. Attorney Jay Davis is here from James W. Davis and Associates for It's the Law. Good evening.
Good evening.
Now, just last week, the tasing death out of Washington County ended in a mistrial. The 9-day trial included 3 former Washington County Sheriff's deputies charged with murder in the July 2017 death of Uri Martin, who was walking the neighborhood and asking for water when he was tased. So, Jay, my first question for you is, what does a mistrial mean in this case?
Mistrial basically means that there was no decision reached. That leaves open for a further trial that can be retried with another jury. It indicates that the jury has to come back unanimous, whether it's an acquittal or whether it's a conviction. So they could not reach that. There's no indication that I've seen on how many it was one way or the other. When they get sort of deadlocked like that, the judge usually issues what's called an Allen charge, and that is instructions that they need to use their best efforts to try to reach a judgment and not consider anything except for what's in the trial itself. And then if they can't, after all of those instructions and after what is believed to be enough time, then it goes to a mistrial. So now they can be retried, or they could just be let go of the prosecutor to say, well, we're not going to try it again. Maybe we didn't have enough evidence or whatever.
Got it. So we answered that a little bit about why the mistrial. Why couldn't the jury, in your opinion, reach that unanimous decision?
Well, it seems like from the facts that I've seen on this trial that they tried to do the murder versus by a felony murder, which means you were in the commission of some other felony, not the murder that is what you're actually charged with. So they wanted to say that this was a felony false imprisonment, that they had no right to stop him, that they stopped him without any lawful authority, and that amounted to a felony itself, and then that murder, the killing or the death of it, arose out of the commission of that felony. And I think that's probably where the jury kind of got hung up on whether or not that the commission of that felony. He apparently probably was lawfully detained according to some law in the books about walking on the streets. That's a little bit unclear. They're not going into that particular county's laws, but supposedly they were using a right to stop by a pedestrian being on a street, which most people think is a ridiculous law. But if in fact it's a law, then it is a lawful stop originally. The detainment is the problem.
So with the deputies, are their charges dropped and are they free to go unless tried again?
No, whether or not they're free to go is depending on the judge. The charges, because they're not resolved, we call it a disposition when they're resolved one way or the other, a conviction or acquittal. Otherwise, they're still pending. And the prosecution then has to decide whether to proceed with another trial or not. So unless the prosecution drops those cases or dismisses those accusations or indictments against the officers, they're still under those. And if they were being held without a bond, they're still held without a bond. The likelihood that they could get a bond after a mistrial gets better because you can only lawfully detain anyone for a certain amount of time, and they have a right to a speedy trial. And if that trial didn't work out for whatever reason, then you have to start really considering whether or not they should be out. I'm guessing the likelihood is they're out on bond anyway.
All right. Thank you, Dave. Definitely a story we will continue to follow here at 41 NBC.
Thank you. Great to see you always.